We're ready to resume. Mr. Tomlinson.
Well, Lord, thank you. Good afternoon. I want to say something briefly now about res judicata and the argument advanced by Google that the procedure that we're proposing works in justice, or potentially works in injustice to other members of the class. I've already referred the court to the terms of 19.6, which is an electronic 812, and the court will have noted that at 18.64a, unless the court otherwise orders, a judgment or order is binding on all parties represented. So, in other words, the court can order at any stage that a judgment will not be binding on a member of the class. That there's no restriction whether that's before or after judgment. So, under the terms of the order itself. So, in a situation posited yesterday where a person is unaware of the representative action until after judgment, and then appreciates that they've suffered significant loss, then they can make an application under 19.64 that for a direction that the order shouldn't be binding on them. As the court will be aware, that doesn't arise on the facts of this case because the limitation period has expired, but of course could arise on the facts of other cases. This issue was considered by the High Court of Australia in a case which I'm going to refer to in more detail in a moment. Perhaps I'll just mention it's a case called Carney and Asanda Finance, where the High Court of Australia was dealing with a rule from New South Wales in materially identical terms to CPR 19.6, and that's at 3485. But under this head, what I take from it is this: that the Chief Justice and Justices Dean and Dawson at 3500 to 3501 concluded that the members of the class might suffer, the fact that they might suffer an injustice as a result of their claims being stopped was a matter that went to discretion and not to jurisdiction. And if where there's a potential for injustice, and obviously in some cases it may be a serious practical issue, it's not in this case, then the court can make appropriate orders as a matter of discretion to deal with. I want now just very briefly to mention the Commonwealth cases. I obviously these cases are of interest to this court because they're dealing with common law. They're the high courts, the highest courts from the jurisdictions in question. They're obviously not in any way binding, but persuasive, and we say of value to look to see how other judges in these jurisdictions have dealt with the similar sorts of issues. I make it clear there's no case dealing with the identical situation that arises, but there is some value in looking at the way to deal with representative actions. The first case is the one I've already mentioned, Carney and Asanda Finance. That was the High Court of Australia in 1995. That was a representative action on behalf of all those who'd entered into regulated finance agreements, and declaratory relief was sought in that action. The relevant rule from New South Wales, which the court was concerned with, and there was no statute governing representative class actions at that time. The relevant rule is set out at page 85, line 5 of the judgment, which is electronic 3494. I won't read it for reasons of time. The New South Wales Court of Appeal said that this was a class action which was inappropriate and that it needed legislation. That contention was rejected by the High Court. The the members of the court considered the English authorities, starting with the Bedford and Ellis and going through to the Irish Rowan, pages 86 to 88, 395, and they approved Justices Toohey and Gaudron, with whom three other justices agreed, approved this statement of the position from a case in Canada at 3498. A class action is appropriate where, if the plaintiff wins, the other persons he purports to represent win too, and if he, because of that success, becomes entitled to relief, whether or not in a fund or property, the others also become likewise entitled to that relief, having regard always for different quantitative participations. So no need for a fund or property, but some common relief. Justice McHugh also gave a concurring judgment where he noted, again, looked at the English cases, and at 3506, page 97 of his judgment, said that I see no reason to confine the rule to cases where there's a common element in the causes of action, plaintiff and the represented persons. If they have a community of interest in the determination of some substantial issue of law or fact in the action, they have the same interest within the meaning of the rule. And we say that that's exactly the position here. The one other point I draw attention to in that case, because it's relevant to an argument that Google advances, which I'll consider in a few moments, is at 3487, page 78 of the judgment. This is the joint judgment of Chief Justices Dean and Dawson. And they say this: much as one might prefer to have a detailed legislative prescription by statute or rule of court, regulating the instance of representative action, Rule 13 makes provision for an action to proceed in a context in which there's no such legislative prescription. The absence of such a prescription does not enable a court to refuse to give effect to the provisions of the rule, and doesn't provide scope for narrowing the operation of the rule. So, as a matter of fact, in Australia, subsequently there was legislation, but at the time this case was decided that there was no legislation. A similar position was the case in Canada, in the case of Western Shopping Centres and Dutton, which is at 3508. That was the Supreme Court of Canada considered the position an action had been brought in Alberta, and Alberta at that time had no statutory provision for class actions, group litigation. The relevant rule of court, again, the Alberta rule of court, can be found at page 542 of the report. That's electronic 3517. The Chief Justice in that case considered, again, the history and functions of class action, starting at paragraph 19 of her judgment, which is at page 3519, and continuing through to 3522. She noted the flexibility of the procedure, its decline and revival, saying this at 3522, paragraph 25. Conditions emerged in the latter part of the 20th century that once again evoked its utility. Mass production and consumption revived the problem that motivated the development of the class action in the 18th century, the problem of many suitors with the same grievance. She then goes on to set out the advantages of class actions in the modern world. We've quoted the passage in our case, and I won't repeat it here, but it's from paragraphs 27 to 29 of her judgment, 3523 to 3524, and it's the principles are unnecessary duplication, saving of costs and dividing of costs. She says, without class actions, the doors of justice remain closed to some plaintiffs, however strong their legal claims, and serving efficiency and justice by ensuring wrongdoers do not ignore obligations to the public. Without class actions, those who cause widespread, this is on page 550 of the judgment, widespread but individually minimal harm might not take into account the full costs of their conduct. Just for any one plaintiff, the expense of bringing a suit would far exceed the likely recovery. And that's, of course, the principle on which we rely in this case. She then goes on to discuss the fact that there is no legislation in Alberta, noting this at paragraph 33. Clearly, it would be advantageous if there existed a legislative framework addressing these issues. The absence of comprehensive legislation means the courts are forced to rely heavily on individual case management to structure class proceedings. She then goes on in the next paragraph, it's at 3526, to say, absent comprehensive legislation, the courts must fill the void under their inherent power to settle the rules of practice and procedure. However desirable comprehensive legislation on class action practice may be, if such legislation has not been enacted, the courts must determine the availability of the class action and the mechanics of class action practice. And we say that that's the case in this jurisdiction as well. And just to paragraphs 35 to 36, she deals with the way that the courts in Alberta have laid down class certification criteria, analogous to those which are set out in the statutes in other provinces. That's at page 3527. She summarises the position at 3523, paragraph 48. And then finally, and most recently, there's the 2020 decision of the New Zealand Supreme Court in Southern Response Earthquake Services and Ross, which is at 3528 of the electronic bundle. That's a case involving a claim by, sorry, I may have got the reference. 3538, I'm so sorry. I said 28. It involved a claim that insurance companies had in effect misled people who had settled insurance claims arising out of an earthquake. And they sought to represent 3,000 policyholders in similar circumstances. The relevant New Zealand rule, which is in slightly different terms, but it was accepted as being effectively the same as the rule in England, Canada, and Australia, set out at paragraph 25 at 3547. And the defendant's contention in that case, as in this case, and as in the other two cases we've mentioned, was that legislation was needed, and there shouldn't be such claims until there was a legislative framework. One finds that at paragraphs 4 and 19. The court again considered the question as to whether comprehensive legislation was necessary, and considered the approach in Australia and Canada, and agreed that those provided a useful precedent for utilising the procedure without legislation. As a matter of interest, and I don't refer to it specifically, but there were various practical issues which haven't been raised by Google in this case, concerning matters such as settlement, discontinuance, funding, and the approach to the discretion, which are dealt with at paragraph 64 onwards. What we take from those cases are these 5 points. Firstly, that the representative action procedure is not constricted by rigid rules. It's a flexible tool of convenience. The fact that it includes a claim for damages is no bar to proceedings as such. Thirdly, the procedure can be used to determine issues that impact on consumers, in large numbers of consumers, in an efficient way. Fourthly, that it serves important societal interests, promoting access to justice and enabling consumers to hold large corporations to account. And fifthly, that the fact that legislative rules are not in place is not a reason to refuse to permit an action to go forward. Obviously, such rules are desirable, but the legislature doesn't always choose to act. And in matters within the province of the courts, the court can act although the legislature has done nothing. And as one example, which is perhaps of some slight relevance in this case, the court will know that for many, many years, the legislature refused to act in relation to a privacy tort. And ultimately, the House of Lords discovered a privacy tort via the operation of the European Convention on Human Rights. It was an area where legislation had often been contemplated. Indeed, bills had been put before Parliament, which isn't the case here. But nevertheless, the court within its own province decided to act. As I say, those cases from the highest courts in Canada, Australia, and New Zealand show, we say strongly, the policy that operates in this area, and the practical issues which inevitably arise, I of course accept, can be solved by the case using its powers of case management.
Mr. Tomlinson, just before we leave this case, I'm just trying to get clear in my mind what it was about. Paragraph 2, page 3541. It looks as though there wasn't an issue about the appropriateness of using the representative procedure, and what the argument was about was use of opt-in or opt-out.
The issue was whether it would be opt-out, but of course, if it's opt-in, it's not really the representative procedure at all. It's a form of I'm not sure what the New Zealand proceedings are, but procedure is. But in England, it would be a group litigation. There was certainly opposition to it being opt-out, as your Lordship sees from the last sentence of paragraph 4.
All right, thank you.
True it is, and I accept this. A few lines further up, it was common ground that there was jurisdiction to order such proceedings. But the defendants were saying, wait for legislation, because the matter was at that stage being considered by the New Zealand Law Commission. Finally, under this part of the submissions, and I deal with it at this stage because this is where Mr. White dealt with it. Mr. White advanced 6 objections to the respondent's attempt to satisfy the same interest criterion by claiming a uniform sum in respect of loss of control. there's a substantial overlap between those 6 points, but I'll deal with them in the order that Mr. White put. Firstly, he said, well, look, this is just a tactical disavowal and doesn't alter the actuality in fact. Well, that's right, but it's irrelevant, we say, because it's perfectly normal for people to limit their claims to take advantage of particular procedures. There are well-established procedures in the courts which are, for example, to which damages limits apply. And people limit their damages so they can use the procedures that are available. That doesn't mean that they're not entitled to more damages, but they've chosen that course. Now, of course, it's the representative that's chosen the course. I accept that, and not the members of the class. But as I've said, the members of the class really have no practical alternative, and if they wish to, could apply for an order under 19.6. Secondly, it said this doesn't alter the legal nature of the claim. They remain individual claims. Well, yes, that's right. But of course, that's right in respect of any claim where there's a common fund. And I don't think it's argued that you can't, if there is a common fund to which people have, to which claimants have entitlement, that they can bring claims to that entitlement in a representative action. The fact that they're individual claims, and I gave the example of to my Lord Sales this morning of a situation where a fee had been demanded which was unlawful in the same sum. Those are individual claims, but it can't sensibly be disputed that they could be brought by means of a representative action. Thirdly, and this really runs on from the other points that I've just been making, it's one thing to limit one's own claim, but the respondent's limiting claims on behalf of millions of people. Well, I've already, without their knowledge or consent, I've already made really the points in response to that. There's opt-out. Claims are not practical in any event unless the people are fanatics or lunatics, as the words go. And of course, this is self-serving by Google. Google's not saying we'd like to give people more. Google's saying we'd like to give no one anything. So it's putting itself out across as representing the interests of the poor disenfranchised class members, but actually what it's doing is seeking to avoid paying anything to anyone. Fourthly, it said that the lowest common denominator is a fiction, which needs to be reviewed from the perspective of the nature of the interference. We agree that the lowest common denominator is, in one sense, it's a fiction isn't the right word. It's an analytical tool that we've devised to meet the same interest criteria. Exactly where it lays and how it works is something we say is a matter of fact, which I dealt with this morning, but we can't deal with at this stage. The fifth point is really a version of the third, that it works in justice to claimants who have larger claims. Well, it's heartwarming to know that Google is concerned about injustices to people whose data it's wrongly processed. But those people, as we've said, if they have larger claims, they can opt out. And finally, it said it's contrary to public policy to artificially limit claims. Well, the authorities that Mr. White referred to really didn't support that proposition. The safeguards are there, and the safeguards are built in because this is a procedure which is subject to the directions of the court, and insofar as have we lost Lord Reid?
had a problem with my, there we are. There we are. Thank you.
Oh, I was afraid we'd lost you entirely. So we say that there's a clear public policy benefit from this procedure, and the public policy arguments to the contrary are really self-serving arguments by Google. There are two other arguments that Google addresses under this head, which I'm going to address in detail in our case, and I don't propose to expand on them to any great degree orally. The first point is this is contrary to the intention of the government, and Google goes into great detail about the various proposals that have been put on the table and have not been followed up. We would say the intention of the government is not the relevant question. If this was contrary to the intention of Parliament, then it might be said that that was a strong argument for the courts not developing the law in this direction. But no proposal, as far as we're aware, no proposal for this collective consumer action has ever been put before Parliament. There have been some sectoral proposals, which have been the Competition Act one, and then one which disappeared in the washout in 2009. But as I've said before, this is something which is in the province of the courts. It's court procedures and the common law, general law rules relating to damages, and it concerns access to justice, which is very much the province of the courts. And the fact that the government, which has other priorities and other concerns, hasn't acted, is we say not a factor that's relevant at all to the court's consideration. The government doesn't necessarily have in mind what constitutes proper access to justice. The third point under this head that's made by Google is the need for rigorous safeguards and primary legislation. We accept, of course, what Lord Sales and Leggett said in their joint judgment in Merricks, which is paragraph 86 at 1318, that there's a risk that speculative actions might be brought, claiming large amounts of damages, where the size of the claims and the heavy costs of defending the action could be used as threats, but blackmail litigation. That's a risk, but it's not a risk which is confined to group actions. This issue was addressed obiter by the High Court of Australia in a case called Campbell's Cash and Carry and Fostiff, which is at 497 of the supplemental bundle. In that case, it was found that the action didn't fall within the representative action rule, and so it wasn't permitted to proceed. But Justices Haynes and Crennan and Gummo, considered obiter paragraph 95, page 522 of the electronic supplemental bundle, considered this argument and said this, that paragraph 95 of the judgment, difficulties thought to inhere in the prosecution of an action which, if successful, would produce a large award of damages, but which to defend would take a very long time and very large resources, is a problem the courts confront in many different circumstances, not just when the named plaintiffs represent others, and not just when named plaintiffs receive financial support from third-party funders. The solution to that problem, if there is one, does not lie in treating actions financially supported by third parties differently from other actions. And if there is a particular aspect of the problem to be observed, principally in actions where the plaintiffs represent others, that's a problem to be solved in the first instance through the procedures employed in that kind of action. It's not to be solved by identifying some general rule of public policy that a defendant may invoke to prevent determination of claims made against that defendant. We adopt those, my lady, we adopt those words. That of course, there's always a risk in any litigation of a certain kind that defendants may be bullied into settling unmeritorious claims, and the court must be astute to avoid that happening and to take appropriate measures. And we do make the point that if there are such risks, they're greater in GLO cases, because the costs in GLO cases are going to be greater than the costs in representative actions, because as I said earlier, GLO necessarily involves not just one claimant and one firm of solicitors, but a whole group of claimants, maybe hundreds, possibly thousands, and many firms of solicitors, and knock on huge administrative costs or potentially huge administrative costs. So the court must, of course, and we accept, take great care to minimise the risks and to strike a proper balance between the interests of claimants and defendants. And of course, it would be preferable if a statutory regime was in place. But if there is no statutory regime, we say that doesn't mean that the courts are therefore powerless to police representative actions and to ensure that its procedures are properly and responsibly used. But ultimately, that's what I was going to say on the first part of the second issue. I can be much more brief on the second part of the second issue, which was the inability to identify members of the class. This is dealt with by the Court of Appeal, paragraph 80. That's electronic 229. In that case, the Chancellor set out the correct legal test, which is it must be possible to say of any particular person whether they qualify for membership of the class by virtue of having the same interest as Mr. Lloyd at all stages of the proceedings. That was the point that was confirmed by Emerald Supplies. And the class must be conceptually clear. It must be possible in principle to determine at any given moment whether someone is in it or not. The Chancellor applied that test and found it fulfilled. That's at paragraph 80. He says Google's objection to that is, well, people may not know whether they're in the class. Their memories may be at fault, and there may be practical difficulties. Well, but ultimately that may or may not be true. But at this point, in considering the judgment, the question is whether the Court of Appeal applied the right legal test, and we say that they plainly did. The conceptual clarity, not practical clarity, is the question. As I say, that's entirely consistent with what the Court of Appeal said in Emerald Supplies. The relevant paragraph is Emerald Supplies is 63, page 1062 in the electronic bundle. There's no question in this case of the identification of the class being contingent on the result of the litigation. Google criticises the Court of Appeal for reversing the judge's evaluative finding of fact. But here, the issue was that the Court of Appeal was saying that the judge had applied the wrong legal test. He'd approached the matter on the basis that the class had to be workable as opposed to being conceptually sound. And that's not the right test. It's not supported by the authorities. Whether it's workable is a different issue. But whether there's a conceptually sound class is what matters, and that's the position here. I'm so sorry.
I think the point made against you, Mr. Tomlinson, I'd like to hear your answer to, is that there are two different ways in which identifying the class members is relevant. One is whether in principle you can identify the members of the class. That's your conceptual clarity point, and I understand your submission on that. But you've now come on to saying that the judge exercised his discretion wrongly because he took account as one discretionary matter the fact that it would be very difficult to work in practice. And I have great difficulty in seeing why that can possibly be said to be inappropriate factor to take into account in the exercise of his discretion. Seems to me that the Court of Appeal have elided the two.
Well, Lord, I haven't quite got there yet. I'm at the moment I'm still dealing with the question of jurisdiction as opposed to discretion.
Oh, I'm sorry. I thought you were saying that the judge was wrong to exercise his discretion on that.
No. Discretion comes later. Here, I'm dealing the criticism, as I understand it, Google's criticism under this head. But we're under issue. We're still under issue 2, not issue 3. We're not dealing with discretion. We're dealing with jurisdiction. And we say the Court of Appeal said, and we agree, that the judge was wrong to take the test as the jurisdictional test as workability rather than conceptual clarity. I'll come on to explain why we say that the judge, the Court of Appeal, were right on the question of discretion in a few moments.
No, thank you. Sorry, it's my misunderstanding.
I'm sure it's my fault. So in terms of identifiability, we say that the judge was wrong and the Court of Appeal were right. That there are many cases in the books where the class boundaries are very unclear indeed. I mean, at any given moment, to know whether someone is a grower of herbs and roots may give rise to. I mean, there can never be a definitive list. People could decide to grow them one year and not the next, but that was no problem in Bedford and Ellis because it was conceptually clear whether someone was a grower of herbs and roots. So, my lords, my lady, we say that in relation to that issue, the Court of Appeal were right. True it is that and this may be why Lord Leggatt raised the point that in the context of paragraph 80, the Court of Appeal also deal not just with conceptual clarity, but they also deal with practicalities. And let me say something about that now. I'll say something more. It's convenient just to deal with it. This is at second part of paragraph 80. The Court of Appeal say every affected person will, in theory, know whether he satisfies a condition that Mr. Lloyd has specified data in the possession of Google be able to identify who is and who is not in the class. Some people's memories may be at fault. These are practical ones. So they're talking about practical matters, but the context is conceptual clarity, and that does bring me on to the third and final issue, which is the issue of the judge's exercise of his discretion, and the Court of Appeal held that the judge had exercised his discretion on a erroneous basis, and that they were entitled to exercise it again. The first point they make under that head, and we say obviously correctly, is that it would be hard for these are the Chancellor's words, it would be hard for the detached observer to accept that the judge was not in any way influenced in the exercise of discretion what he decided on the first two issues. I mean, the judge had ruled that the damages of the type sought by the representative claimant were not available as a matter of law, and comprehensively dismissed the respondent's arguments in relation to all of those matters. And he then dismissed all the contentions of the respondent in relation to the constitution of representative actions. And that is an important factor, we say, that the Court of Appeal doesn't make explicit how it takes that into account. But obviously, if the judge is wrong on the Court of Appeal's findings, the judge is wrong on the two basic issues of law, and the Court of Appeal takes the view that that's influenced his exercise of his discretion. That of itself is a basis for challenging that exercise. The respondent criticised the Court of Appeal summarises what we said in we said on the appeal about the factors that the judge took into account that he shouldn't have taken into account. There were 5 factors in relation to the first 2, namely that the main beneficiaries of the claim would be funders and lawyers, and the fact that the litigation would generate significant costs and the amount recovered by each class member would be modest. The Court of Appeal say that he's entitled, it would have been better for him to invite argument on the matters I've mentioned, but he was justified in taking them into account. We don't challenge that to say, safe to say this, that if those 2 facts were right, then obviously he would be entitled to take them into account. But actually, on both points, factually, the judge was wrong. That on a calculation, and these were not matters that were addressed in argument or put to us by the judge as matters he was thinking of, but on the figures that were put forward before the court, and obviously these are simply guideline figures. If the award of damages was between £1 and £3 billion, the overwhelming majority of that sum would be damages payable to the claimants, or if not to the claimants, repaid to Google. The position was that the main beneficiaries, just in money terms, were not the funders or lawyers. So although we accept the judge was entitled to take that into account, as the Court of Appeal said. He'd factually, he'd not got the factual position right. The fact that the litigation would generate significant costs and the amount recovered by each class member would be modest, well, that is right. But insofar as it's a relevant factor, we say it's really of a very little weight, and the judge, he might have been entitled to take it into account, but it's difficult to see how it could really have been of itself a significant factor one way or the other, because obviously any large-scale litigation of this form is going to generate significant costs, and also it's going to be funded, and the funders are going to take money from it. But my lords, my lady, the Court of Appeal accepted that he was entitled to take those into account, but the factual, the third factor, again, I enter this qualification that the judge said that none of the millions of affected individuals had come forward to complain. That's what he said. It's not right. The judge wasn't right to proceed on that factual basis. There are tens of thousands of people who've registered the complaints in relation to this case. It was again a matter that wasn't addressed by in evidence. The judge didn't raise it at the hearing. But the two matters the Court of Appeal said he wasn't entitled to take into account were first of all the absence of complainers. I'm so sorry. It's not the fourth and fifth matters were the inability to identify members of the class, and the members of the class are not authorised to claim. Now, I now come on to the point that was raised by my Lord Legate. Of course, I accept that practical difficulties in identifying the members of the class is a relevant factor when considering the exercise of discretion. The position was, and so that the court just has the evidential position. The evidence put forward by the respondent is in Mr. Ognall's second witness statement, paragraph 71 to 72. That's pages 547 to 548. And there was certainly one aspect which required self-certification, which was whether a person had changed their default security settings. That was something where there may well have been practical difficulties. The situation was that Mr. White says, well, your lordship's ladyship may remember from yesterday that Mr. White talked about the difference between the positions of the position of the already hads and the never hads. So sorry, give me a moment. Says that that's in relation to the cookie, because some of them would have had the cookie lawfully placed on their iPhones before the relevant period. And he said that Google's records don't reveal the already hads. The evidence put forward by the respondent was that such records would be available from Apple. That's at paragraph 71 of Mr. Oldmore's statement at 547. Put shortly, the position we said was wholly unclear as to identifiability, and it was impossible. That the Court of Appeal was right in this regard, that although the judge was entitled to take into account practical questions as to identifiability, the material simply wasn't available to him at that stage of the action, at the very earliest stages of the action, to know what the situation was. So in that respect, the Court of Appeal were right to criticise the judge taking that into account. And the final matter that the judge, the Court of Appeal criticised the judge for was to take into account the fact that the members of the class had not authorised the claim. Well, of course, Mr. White is right to say that the judge must have known. Obviously, he did know that the members of the class in the representative action are not required to authorise the claim. But of itself, we say that can't possibly be a reason not to permit a representative action to continue, because it would apply to all representative actions. By definition, there is no authorisation of the claim. So the Court of Appeal were right to criticise the judge for taking that into account. It was something that was it's not just a neutral factor. It's a factor which has no relevance whatever we say to one way or the other to whether it should go forward. So, my lords and my lady, we say that the Court of Appeal were right to overturn the exercise of the judge's discretion. And there were, I should just add this, that there were, of course, other matters that the judge should have taken into account and didn't, which weighed in the balance on the other side. The position we're here dealing with ex hypothesi unlawful conduct affecting fundamental rights, which, if the judge was wrong on points 1 and 2, which is the ostensible basis on which he's exercising his discretion, a remedy would be available for individuals who otherwise would have no remedy. Access to justice would be provided in circumstances where otherwise there would be no access to justice to vindicate fundamental rights. That's a matter which obviously should have weighed in the balance in the judge's exercise of his discretion, but doesn't appear to have done so. So, my lords and my lady, we do say that the Court of Appeal were right on that issue as well. And they were entitled to re-exercise the discretion themselves. And standing back, if the position, if we're right on the first and second issue, if the position is that we have a claim for damages on a uniform per capita basis, however it's analysed, and if that is sufficient to satisfy the same interest criterion under CPR 19.6, it would be extraordinary if, before the proceedings have been served, but before we know anything at all about Google's defence, it can be said that the action should not proceed. We don't know what Google, the court may not know, but in Vidal Hall, the case never got to the stage of the service of a defence. The Vidal Hall was a fight about service out. The judge gave permission to serve out. Google's appeal to the Court of Appeal was dismissed, and Google then appealed to this court, and then the case was compromised, and that appeal was withdrawn. At no stage was any defence served. So Google's substantive case on this issue was never set out. We don't know. It's not been pleaded in this case either. So we really know very little. We certainly don't know in terms of a pleaded case Google's response. And to say that nevertheless in those circumstances the case should be the court should exercise a discretion to prevent a meritorious case providing remedies to a large number of people. That should be, the court should say no, the matter of discretion, it shouldn't proceed at the outset. We say would be an extraordinary exercise of the discretion which the court ultimately has. We don't, and the court will be clear about this. We don't say that if we are granted permission to serve out, that therefore follows that the action can proceed forever and to judgment, trial and judgment if necessary. Of course, the court retains a case management jurisdiction, and the court may, when the pleadings are in and disclosure has taken place, the court may, of course, say, well, actually, now we know the facts. This is not an appropriate action to proceed. We obviously accept that that's a possibility. We wouldn't possibly seek to argue to the contrary. But to say at the very outset that the case shouldn't go ahead is, we say, obviously wrong. So my lords and my lady, for those reasons, we say that the Court of Appeal were right for the reasons given by the Chancellor in his judgment. That although this is a novel and innovative use of the procedures, he described it is a proper use of the procedure. It's a proper way to provide a remedy and access to justice in a case of this kind. It's not the ideal way, because the ideal way would be a legislative framework. But in the absence of such framework, we say that there's nothing to prevent the Court of Appeal, nothing to prevent this court from permitting the action to go ahead in its current form. My lords and my lady, I have a minute left. But unless there's any matters in which I can further assist the court, those are my submissions.
I'm not encouraging you necessarily to take advantage of it, but you have been allocated until 3:15.
Oh, have I?
Yes.
I thought I'd been allocated till 3.
Well, the document I've been given has you down for 3:15, and then well, I beg your pardon. I'm looking at yesterday. No, you're quite right. Thank you.
I was going to think of a few more arguments and take another 15 minutes.
No, thank you very much indeed, Mr. Tomlinson. Well, we turn then to Mr. Fenner on behalf of the Information Commissioner.
Yes, my lord, I was starting to panic about how I was going to fit mine into 15 minutes.
I'm sorry to have misled you just now.
My lords, my lady, I propose to divide my submissions on behalf of the Information Commissioner into 3 parts. First of all, to address the importance from the Commissioner's point of view of considering the issues in this case on the basis that data protection rights are fundamental rights. Secondly, to touch on the wider potential effects of a narrow interpretation of damage in Section 13 of the 1998 Act, particularly in connection with the Commissioner's regulatory role. And thirdly, I'll make some general observations on the other written interventions that are before the court. The Commissioner's written submissions, which you may have had an opportunity to look at, are in the supplementary bundle, starting at page 115. And you may have seen that in her written submissions, the Commissioner emphasises the point that the right to control one's personal data is a right that has its own intrinsic value. In other words, the ability to decide what happens to one's personal data, to exercise autonomy over it, is a right that has value for the individual, quite separate from any economic value, for instance, that the data may have. The freedom to choose whether to share one's personal data, and if so, with whom and on what terms, and subject to the controls laid down in the law, is a valuable and fundamental right in itself, as well as being an aspect of broader rights to privacy and personal autonomy. And the idea of having control over one's personal data is not an abstract or an intellectual concept. In fact, the ability to exercise control over what happens to one's personal data is commonly identified in studies as a central feature of what citizens want and expect from data protection rules. And you can see an example of that in the recent study and report by the Norwegian Consumer Council, which is quoted in the second intervener submissions at supplementary bundle page 137. And you'll see that the extract from that report, which is cited there, encapsulates the sense of disquiet that many people have when using their mobile devices or accessing the internet, knowing that what they do on their phone or computer is being comprehensively tracked, principally to sell and to provide targeted advertising. And as you'll see in that report, which is actually entitled Out of Control, that report identifies the sense of powerlessness that many citizens feel in the face of what seems to be a massive and seemingly unavoidable collection and processing of personal information. And I do, if you have the opportunity, encourage you to have a look at that report, at least the summary of it. There's a link to the full report in the footnote on supplementary bundle page 137. But it has, in particular, a useful description by a regulator of how behavioural advertising works. I've noted that in some of the exchanges yesterday and today, various analogies have been suggested about the processing in this case, and perhaps a suggestion that many of those who were caught by Google's conduct may have been affected only to some trivial degree. But that report does perhaps provide a clearer picture of the extensive data processing and profiling and reselling of data in issue here, and it does make clear the concerns that consumers and regulators have about the fact that all of us have our behaviour and our habits and our interests tracked and profiled every time we use our mobile phones, invariably in a way that is not transparent. So the basic point is that the idea of a person having control over their own personal data, the value that individuals place on that right, is not a theoretical construct. It is, in practice, a right that, when asked, many people really care about. And of course, data protection rights are also often relevant to the exercise and protection of other fundamental rights, as this court and both domestic and European courts have recognised. Having robust data protection laws is necessary, for example, to guarantee the effective exercise of the right to freedom of thought, freedom of expression, freedom of assembly, and as indeed this court saw in El Ghazouli, sometimes even relevant to the right to life. And again, as we say, as the Commissioner points out in her observation, in her submissions, like other fundamental rights, ensuring effective protection for data rights is important not just for individuals but also to society. And this is a point which is developed in paragraphs 19 to 21 of the Commissioner's written submissions. In particular, incidences of loss of control of data, particularly where they affect a large number of people, undermine the principles of fairness and transparency which are at the heart of data protection law. Such incidents have a negative, significant negative effect on wider trust in the system of data protection. And the basic point is that if people don't have confidence that the law affords proper and effective protection for their data rights, that breakdown in trust risks causing wider economic and societal harm. So to give just one example, low trust in data protection systems and in the ability to enforce the underlying rights might well inhibit individuals from participating in vital public health initiatives, such as those that we've seen in recent times in response to the pandemic. So the Commissioner does wish to emphasise that, considered in its wider context, a loss of control over personal data causes harm in and of itself. It harms both the affected data subjects and society at large, and that is whether or not there is further specific or material damage that individual data subjects may experience as a result of any particular incident. The primary harm suffered by data subjects is the loss of control over their data. That is the principal injury. Whether or not it is accompanied by further harm is a separate issue. Now, where individuals consider that their data protection rights have been infringed, they have a specific right in domestic law to an effective judicial remedy. And the relevant provisions in the UK GDPR are set out in the Commissioner's written submissions at paragraph 15, which is Supplementary Bundle 119. And I refer you to those because in the bundles you have the original EU GDPR, but as in so many cases now, as a result of statutory instruments, the blue pencil has been taken through some aspects of the GDPR. So we now have what's called the UK GDPR as our statutory regime. And if you're able to look at paragraph 15 of our written submissions, 15 little c in particular, at page 119 of the supplementary bundle, you'll see that Article 79 of the UK GDPR stipulates that without prejudice to any available administrative or non-judicial remedy, including the right to lodge a complaint with the Commissioner, each data subject shall have the right to an effective judicial remedy where he or she considers that his or her rights under the regulation have been infringed as a result of processing in non-compliance with the regulation. And then over the page, Article 82.1 of the UK GDPR makes it clear that data subjects' rights include a specific right to compensation where a person has suffered material or non-material damage as a result of an infringement of this regulation. So that's the provision in the current UK regime, which takes over from section 13 of the 1998 Act and the previous provisions of the directive. I should, while I'm on that page, can I just point out there's an erroneous reference in our written submissions to Article 86.2 of the EU GDPR. That should be to Article 82.6. And that provision in the original EU GDPR, which is referred to there, that draws a specific link between the right to receive compensation under Article 2 and the right of effective access to a judicial remedy in Article 79. And if you, the bundle references for those provisions of the EU GDPR are in the main bundle at pages 826 and 827. Now, the precise nature and scope of any judicial remedy is, of course, for the courts to determine in the light of the facts of individual cases. But the point is that an effective judicial remedy must be available to each data subject in respect of any infringement of their data protection rights. And as I've just shown you, unlike, for example, in the Strasbourg context, that includes where there is non-material damage in the form of, for example, a loss of control, a specific statutory right to receive compensation. Now, as we go on to develop in paragraphs 22 to 27 of the Commissioner's submissions, it is not the case, it's not the Commissioner's view, that every breach of data protection obligations will result in a loss of control. And this is a point that was explored with my learned friend Mr. White yesterday. And I think Lord Burrows asked Mr. White yesterday about examples of infringements of data protection rights that would not involve a loss of control. And we give, in paragraph 27 of our submissions, we give the example of a purely technical infringement of record-keeping requirements under the legislative framework. And one can also think of other examples, such as a failure to carry out an adequate impact assessment before carrying out a particular form of processing, or a failure to implement appropriate technical and organisational measures to protect personal data. And actually,
or a failure to respond to a data access request.
Yes, I think that was one of the examples that was given yesterday by Lord Burrows, precisely. So those kind of infringements, which may be quite serious from a regulator's point of view, would not automatically involve a loss of control over personal data for the relevant data subjects. There are, by the way, some other examples in Mr. Justice Warby's judgment at paragraph 56, which includes holding data for too long, or holding inaccurate data without it necessarily having been shared or disclosed to anyone else. So that in my submission accords with the analysis that I think Lord Burrows was getting at in some of his questions earlier today, particularly in relation to the relevance of culpability. So for there to be any claim at all, there needs to be a breach, obviously, of legal provisions. And that breach will have to be either deliberate or negligent, which I think reflects the point that Milady made about that being an element of the tort. But when it comes to identifying whether there is a loss of control as a distinct harm, it's not clear that culpability will really be relevant to that. So it is, in my submission, important to draw a distinction between the breach of the statutory obligations and the harm here. You have a breach of the regulation that gives rise to the possibility of a claim. Loss of control is a distinct harm which will arise on the facts in some cases and not in other cases a breach. And then compensation for that harm is then the third question, which is to be determined on standard tort principles, and where culpability, of course, may then be relevant again among other factors. Now, no doubt, the loss of control will need to be of a certain seriousness to justify an award of compensation. I think we accept that. But it's also clear that there will be cases where that is met. And as we acknowledge in the Commissioner's submissions, it's also true that not every breach of the legislation must necessarily give rise to an entitlement to compensation. A court can obviously decide on the facts of a given case that a monetary award is not warranted, and if the injury is minimal, the courts are able to reflect that in the quantum of any damages that are awarded. My Lord Legate, in seeking, I think, to understand the scope of Mr. Tomlinson's case this morning, posited the idea that you have these cases where large sums of money are paid to large numbers of people without, to use my Lord's words, any actual harm. In other words, no evidence of distress or misuse of data by third parties or financial loss. But obviously, on the basis of the submissions that I'm making, as the Commissioner would see it, in many of these cases, there is actual harm. The loss of control, even if it doesn't arise to the level of distress, is a form of damage. It's an invasion of privacy and of personal autonomy that comes from the dissemination or loss of data to those who are not entitled to access it due to the negligence of the data controller. Now, of course, in this case, that doesn't really arise because it's alleged in any event that it's alleged in this case that the personal data of millions of iPhone users was deliberately and covertly taken by Google for its own commercial gain without consent, and then was used to track data subjects' online behaviour without any transparency or any ability on their part to control this usage. But equally, where you are talking about cases where there's been a hack, but no evidence of subsequent misuse or loss, one has to recall that a data controller has been entrusted with data. It has legal obligations, inter alia, to put in place adequate technical and organisational measures to protect that data. And controllers owe those obligations to data subjects. And if they fail to meet those obligations, either negligently or deliberately in breach of the statute, and that leads to third parties accessing the data where they would otherwise not have been able to do so, then in my submission, those data subjects have suffered an injury to their right to control their personal data, their right to share it and to have it processed only in accordance with the safeguards and provisions of the statutory framework. And that injury to that right, that harm, has been suffered before one even gets to the further question of whether there may be individual distress or whether there's a particular economic or other loss that follows from that loss of control. There are also undoubtedly cases that involve a serious loss of control where there may be no material damage or distress, and we give the example in paragraph 20 of our written submissions of the loss of control of the data of children who are too young to understand the loss and its consequences. So the question of whether there is a loss of control, and if there is, its seriousness, is one that depends on the facts of the individual case. And the Commissioner's submission really is that the courts are well placed to assess those matters and to determine whether and what compensation may be appropriate in any case, without imposing an artificially narrow construction on the meaning of damage under the legislation. Now, before moving on to the next part of my submissions, I should address a suggestion by the third interveners, who are trade associations for the pharmaceutical and health tech industries. And what they say at page 157 of the supplementary bundle is that there is no single or unitary concept of control applicable to all data subjects, and that to speak of control of personal data is imprecise to the point of being meaningless. And really the point that they're seeking to make there is that there are lots of circumstances in which data subjects do not have control or autonomy over their data because their ability to dictate what happens.
I couldn't hear what you said.
Sorry, Lloyd. That was my, just to give an example of tech, that was my iPhone responding, I think, to me using the word serious, which sounded a bit like Siri. I'm sorry, I thought I'd turned that off. In the point that's being made there is that there's no meaningful right of control because there are all kinds of constraints on control imposed by the statute. But in the Commissioner's view, it's not correct or meaningful to say that there is no right to control personal data under the legal regime. My learned friend, Mr. Tomlinson, already referred you earlier to recital 7 of the GDPR, which is quoted in the supplementary bundle at page 135, and which states unequivocally that natural persons should have control of their own personal data. And then recital 68 of the GDPR, which I don't think you have in the bundle, but it does talk about further strengthening data subjects' control over their data. And there are references, which I think you've been referred to in recitals 75 and 85, to data subjects losing the right to control their personal data. So the regime concept of control by data subjects is explicitly identified. Now, of course, it's the case that the legislation provides a number of lawful bases for processing personal data without consent, but it does so subject to various safeguards, including the right of data subjects to be informed of the processing, to have the right of access and to object in certain circumstances. And that still amounts to control, albeit subject to limited exceptions and derogations. And it is a form of control that can be lost if personal data is processed in breach of those legal requirements. The second part of my submissions concern the point which is addressed at paragraphs 31 and following of the Commissioner's written intervention, namely some wider points that arise from the argument that the term damage under the legislation should be taken to exclude cases where there's no evidence of distress or material loss. And there are 3 points. First of all, a short point about the Commissioner's regulatory functions. A second point about the impact of such a narrow construction on those regulatory functions, and then briefly a point about discrimination. First of all, and this is the point that begins at paragraph 31 of the written intervention, the Commissioner does obviously have an important role as the statutory regulator under the legislative framework. but that role is complementary to private enforcement and the role of the courts in upholding data rights. It's not a role that can be pleaded in aid as a substitute or indeed as a means of addressing each and every infringement of the law. As I've shown you, the legal framework draws a clear distinction between the right to lodge a complaint with a commissioner and obtain an administrative remedy, and the right to an effective judicial remedy, including, where appropriate, compensation. Now, of course, some problems obviously can be efficiently addressed by means of public regulation. For example, some administrative failure that calls for regulatory advice or some targeted investigation. But the right of individuals to obtain redress in the form of compensation for specific breaches of data protection law is not a right that the Commissioner has any power to enforce. There is no power on the part of the Commissioner to order or obtain the payment of compensation to data subjects. That is expressly a task for the courts, and it's one of the reasons why there is a specific right to have access to an effective judicial remedy. So it isn't an answer in this case for the appellant to say that wide-scale breaches of data protection law can be dealt with by way of regulatory enforcement. They can be addressed by the regulator, but that's not a process that's capable of providing individual redress or satisfying the right to an effective judicial remedy and to compensation. The second point is the one that's noted in paragraphs 33 to 35 of our written submissions. And it's this point, it is that a narrow construction of the concept of damage may have perhaps an inadvertent impact beyond section 13 of the 1998 Act and the private law matters in issue in these proceedings, because the concept of damage resulting from breaches of data protection law is one which is used elsewhere in the regime. So looking at paragraph 34 of my written submissions, under section 150(2) of the 2018 Act, in deciding whether to give an enforcement notice in relation to various types of failure to comply with the law, the Commissioner has to consider whether the failure has caused or is likely to cause any damage or distress. And to similar effect, under section 155(3)(c) of the 2018 Act, Commissioner is required to have regard to any action taken by the controller or processor to mitigate damage or distress suffered by data subjects when deciding whether to give a penalty notice and determining the amount of the penalty. So it's merely to highlight the fact that a decision by this court on the construction of damage in section 13, which would no doubt be said to apply equally to the use of the word in other parts of the legal framework, and which is so narrow as to exclude a loss of control by itself, would therefore potentially constrain the scope of the Commissioner's ability to take regulatory action in cases where data protection law has been breached, but where there is no evidence of material damage or distress. Yes, my lord.
I just wonder whether you're putting it a bit too strongly. From the text that you've set out here, it's just an obligation to have regard to these matters on the part of the Commissioner. That seems to imply that the Commissioner could rely on other considerations to take regulatory action if she thought it was appropriate. Is that not right?
There are a range of considerations which actually under the GDPR, which are then carried into the 2018 Act, have to be taken into account. But you see this, I think there's already been reference to the penalty in the British Airways case. In penalties, that when the Commissioner investigates a data breach, she is not carrying out an investigation into whether individual data subjects have suffered distress or any financial loss. And it has been argued, one can see from the public penalty notices in those cases, that the data controllers argued that in the absence of any evidence, or the Commissioner having any evidence of distress or material damage, that was something which had to be weighed heavily in the decision about enforcement and penalties. And the Commissioner's view is simply that if damage is to be interpreted as only including those circumstances where there is either evidence of distress or evidence of financial loss or some other material damage, then that would seem to suggest that those considerations, albeit they're one of a number of considerations, would not be in play in the cases where the Commissioner doesn't have such evidence, where you have a mass loss of control, for instance, but no specific evidence of financial harm. And that, in the Commissioner's view, would be an unduly narrow interpretation of what is meant in those provisions about damage and distress to data subjects.
But in the circumstance of this case, the judge at paragraph 59 identifies that there may well be for individuals significant harm on a narrower basis. I would have thought that the Commissioner didn't, in deciding whether to take regulatory action, could have regard to whether some people within a greater mass are likely to be affected and take that into account without actually having to determine case by case whether each individual did in fact suffer harm. Would that not be true?
It might be true, although it gives rise to the same problem in a way, whether you're talking about individuals or groups of individuals. I mean, the Commissioner's view is that if a large number of data subjects have had their data stolen or lost through the negligence or culpability of a data controller, then they have per se suffered damage. They've suffered harm of the type that I've described, namely loss of control of their data. And that's the Commissioner's view of those provisions. That's the basis on which she takes regulatory action and enforcement action at the moment. And I'm merely making the point that if the court were to determine that the word damage in this regime does not include mere loss of control without further evidence, then that would obviously have, it would have to be taken into account in the exercise of those regulatory powers.
Yes, thank you.
So that's the point on those provisions. My final point, sorry, my Lord Leggett.
Yes, I just wanted to ask you, Mr. Patel, it's all very well for your client to intervene in these proceedings and share on the claimant in trying to get some form of redress for what appears on the face of it to have been an egregious breach of the data protection law. But what has your client done about it, exercising her complementary powers?
Well, my Lord, I do, in fairness to my client, have to take issue with that. We are not intervening. The Commissioner has not intervened in any sense to cheer on the claimant, and I hope we're making no submissions on CPR 19.6, for example, or on the appropriateness or otherwise of that procedure. But the Commissioner does have a statutory duty to monitor and to promote the effect of data protection rights and the regime, and I hope that the submissions I'm making are helping to assist the court in understanding some of the specific aspects of the regime which are relevant. To answer the second part of your question, the breach in this case happened, I mean, around 10 years ago under a different regime, under a different Commissioner. My understanding is that at the time the view was taken that for various reasons, you've heard that there was action taken in the United States and elsewhere, but for various reasons, no, it didn't meet the criteria for enforcement action at the time. But obviously the regime is completely different now, and if this situation were to arise now, one might expect there would be a different approach.
Presumably you can't investigate it because you're referring to your powers as those conferred by the 2018 Act in schedule or whatever it is.
Currently, yes. So could we start an investigation now? I think probably under the transitional arrangements, it might still be possible to investigate breaches which occurred under the old provisions. But I'm not sure about that, my lady. Maybe I could check.
Yes, please.
The third point under this heading, I'm conscious of the time, was a short point about discrimination, which you will have seen raised in the fourth intervener submissions at supplementary page 164. And that is simply that if you read the concept of damage as excluding loss of control without more, then that is liable to have a discriminatory effect. So, for example, the example I've already given of children who are too young to experience distress, or others who may have cognitive impairment or learning disability, would not, on the appellant's case, be able to claim compensation within terms of section 13. So you would have the bizarre situation where those who are perhaps most vulnerable have the least protection. And there is, in my submission, a good analogy with false imprisonment, which my Lord Leggett mentioned yesterday. Absent a valid lawful reason, depriving an individual of their liberty is per se unlawful, and actionable in the tort of false imprisonment, and whether or not such an individual has been or could be distressed by it may be relevant to quantum, but it doesn't affect the threshold question of that individual's ability to claim compensation for the harm caused by the imprisonment itself. And finally, my lord, a brief observation on the other written interventions before the court. Broadly speaking, they fall into two categories: those that emphasise the importance of data protection rights and the practical ability to enforce them, and those that express concern about potential adverse effects of too broad an approach. And the Commissioner would invite the court to resist the idea that there is here some kind of binary choice, because on proper analysis, there is no conflict between strong enforcement of data protection rights and technological innovation. The sixth intervener raises this point, Supplementary Bundle 207, and mentions the dual aims of the GDPR as being respect for fundamental rights and promoting economic and social progress. And it's quite true that those two aims are there, but contrary to what the sixth intervener goes on to argue, they're not in tension with each other, because a legal framework that provides strong protection for data rights, underpinned by effective enforcement, in fact enables and supports the economic and social aims of the data protection legislation. And again, you see that in recitals 6 and 7, which refer, for instance, to technology further facilitating the free flow of personal data and to the importance of creating trust to allow the digital economy to develop. So that depends, indeed it requires in the Commissioner's submission an effective regime, both effective enforcement by the regulator and effective enforcement by the courts of the legal rights of data subjects, including the right to obtain an effective judicial remedy by way of compensation in appropriate cases. My Lord, just finally, to respond directly to a point that Lady Arden asked about the role that the Commissioner might take in the context of any settlement and distribution of an award. As I said, the Commissioner doesn't make submissions on CPR 19.6 beyond the points that I've made about effective judicial remedy and the complementary role of the regulatory regime. But under section 115.3 of the Data Protection Act 2018, which I'm afraid you don't have in the bundle, the Commissioner's functions include a duty to advise Parliament, the Government and other institutions and bodies on legislative and administrative measures relating to the protection of rights and freedoms with regard to the processing of personal data, and a power to issue on the Commissioner's own initiative or on request opinions to such institutions and bodies, as well as to the public, on any issue related to the protection of personal data. And my instructions are that in the light of those wide statutory duties to provide advice and assistance, obviously if the court invited the Commissioner's assistance in a given case concerned with the statutory rights of data subjects, the Commissioner would no doubt use her good offices and expertise to assist so far as she could, recognising, as we do, the complementary role of the regulator and the courts in this area. My Lord, unless I could assist the court further, I'm very grateful. Those are the submissions I wanted to make on behalf of the Commissioner.
Thank you, Mr. Senna. So in that case, we return to Mr. White for the appellant's reply.
Thank you very much, my lords, my lady. Early on in Mr. Tomlinson's submissions yesterday afternoon, he asserted, as he has done in his case, that Mr. Lloyd could bring a standalone claim for breach of his own data protection rights, or get together a group of affected individuals so that they could pursue a GLO. I don't want to be taken to accept that in the absence of significant harmful consequences for an individual. Mr. Lloyd, at present, no more than any member of the represented class, alleges any significant harm. He merely pleads loss of control over personal data interchangeably with infringement of his right. And whereas it's correct that in the Biddle Hall litigation, the Court of Appeal held that claims could proceed on behalf of 3 individuals who had suffered serious distress, that was because they had suffered harm. At the minute, Mr. Lloyd, as I say, pleads no harmful consequence. My Lord, the second point early on in Mr. Tomlinson's submissions that I wanted to respond to was he said in his introductory remarks that there was no imminent prospect that the legislature would act. His submissions were noticeable by their absence on the GDPR and the DPA 2018, where we submit that legislative choices have been made about collective proceedings for compensation on an opt-out basis in the field of data protection. It is not simply a blank slate where Parliament hasn't and the EU legislature hasn't been active. Both have been active and have made legislative choices. My Lord, the third point, a series of points came in close succession in Mr. Tomlinson's opening remarks, was to criticise our suggestion that regulatory action by the ICO may be more appropriate than class action development, where no significant harmful consequence is alleged by the individual claimants. I would only point out that although it is right, as Mr. Fitzgerald just said, that the ICO can't order individual compensation awards, the government, in its Section 189 response, which we quote in our case, paid very significant regard to the availability of regulatory action by the ICO and its perceived adequacy when considering whether it was appropriate to legislate to introduce collective opt-out proceedings in this area. Lord, then, still yesterday afternoon, there was some discussion, particularly between my learned friend and Lord Reid, about the problem of res judicata or estoppel arising from the proposed representative claim. And Mr. Tomlinson said then, as he repeated, I think this afternoon, that the answer was to be found under CPR 19.64A, which would allow the court to direct that any particular person should not be included within the represented class. We respectfully agree with both of the academic commentators whose work I drew on yesterday, that that is unrealistic. And it's unrealistic in our submission for at least 4 reasons. The first is that the unrepresented the represented claimants with the greater level of claim may not know of the action at all. In a class of 4 million, that seems almost inevitable. Even if they know, they may not know of a concession that their individual circumstances are irrelevant, or if they catch wind of that, they may not quite understand it. It is rather a difficult concept for a layperson. They may also not know, as Lord Sales observed in a question to my own friend, that they have a significant claim. But there's a fourth point, which hasn't yet been touched on, which is for a layperson to make an application under CPR 19.64A would not be a simple matter. They'd require legal advice, they'd incur legal costs, and it wouldn't necessarily be self-evident that it would be granted, particularly if made at a late stage. Case management considerations of the sort that often arise in group litigation when considering, for example, cut-off dates, may militate against directing that people fall outside the class. My Lord Leggett.
All the points you're making, Mr. White, could be made as reasons why it's very difficult for any individual to bring a claim at all. And it does seem a little rich for your clients to argue that the theoretical possibility that somebody who's shown no indication of bringing a claim in all the years up to now might in theory have brought a bigger claim is a reason why nobody should get any compensation at all.
Well, my lord, I don't. I see that, and I see the common sense force of that. But the proposed system has to work. It has to work in other situations where that riposte might be not as easily made. And the academics who
It doesn't have to work exactly the same in every situation. It might be a discretionary factor, which means it would be quite inappropriate in another case. But I find it hard to see why in this particular case it should carry any weight at all.
Well, my lord, I make it borrowing the clothes of the academics who make it with less self-interest, and it's either a good point or it isn't. Well, the next point I wanted to touch on was a point that both Mr. Tomlinson and Mr. Fichenna have made, namely that the suggestion that the judge's approach might leave children or those unable to feel distress without compensation. Now, that wrongly assumes that the judge drew a bright line at distress. He didn't, and one sees that in both paragraphs 57 and 59 of his judgment. He expressly referred at 57 to material loss, emotional harm, and other consequences for the data subject. And in the same, in 59, in the last words of the paragraph, a person who objected to receiving such material might say that its delivery caused irritation and or that in any event it represented a material interference with their freedom of choice over how to lead their life. The and or separates irritation, a way of characterizing distress, from something other than distress. And my lord, in the Cullen case that I began with yesterday, the formulation of harm extended beyond distress to other harmful impacts. And so, my lord, the suggestion that the judge drew a bright line at distress, which would rule out children or others, is in my submission incorrect. He was careful, both in his formulation at 57 and 59 and his analysis of Gulati, to recognize that there could be harmful consequences other than distress. Lord, I then turn to the submissions made this morning by Mr. Tomlinson. He emphasized his reliance on the case of Holford, which was then discussed with two members of the court. In our submission, there is in paragraph 76 of Holford relatively little reasoning for the court to fasten on to. It appears that it was concerned that the purpose of the interference was one which impacted on private life. It was to gather evidence to use against her in her discrimination proceedings. And we would respectfully adopt my Lord Sale's suggestion that what the court was really doing was saying that that purpose was capable of increasing the distress, not in the sense of psychiatric injury or impact, but the distress felt by the claimant. But in any event, my lord, citing a single case doesn't affect the practice of the Strasbourg court, to which we have drawn attention to Lord Millett's encapsulation of that practice in Cullen and the practice direction on just satisfaction issued by the court itself. It is a case where, with limited reasoning, the award was made, and we can see it, but it doesn't affect the overall practice which we've put in place, put before you. A little later today, my Lord Reed raised with my learned friend the BA group litigation order, and Mr. Tomlinson said, rightly, that the judge had accepted a submission that a GLO was not practicable in this case. But my lord, what he meant by that was it wasn't practicable for a class of 4 million. It would be practicable if those who considered that they had been harmed or had suffered harm as a result of the safari workaround opted in to a GLO in the same way that the members of the BA group litigation order have opted in. It's only impracticable if it's necessary to capture all of the 4 million plus that the represented class captures. It's not impossible or impracticable in any other sense. My Lord, there was some discussion later in Mr. Tomlinson's submissions about the appropriateness of the judge's reference at paragraph 74 of his judgment to those individuals whose attitude was either happy or indifferent at the use of their BGI to enable the service of individualized or tailored advertisements. And Mr. Tomlinson suggested, as I understood his submissions, that it was somehow inappropriate to look at the individual attitude and the way that varied between members of the class. In our submission, it's not inappropriate to look at individual attitude in this way, and there's a case which illustrates that very neatly in the supplemental authorities, which I went to very briefly yesterday for a different purpose. It's the case of Watkins, which is at page 249 of the supplemental bundle. It's the case I mentioned where the House of Lords decided that it was inappropriate for the tort of misfeasance in public office to be actionable per se. But the interesting feature about Watkins, which was a case about the opening of a prisoner's letters by prison officers, some of whom had acted in bad faith, was that when the judge who made a finding at first instance that no harm had been suffered, when the judge considered whether any harm had been suffered, he specifically found that the prisoner, who was an extremely litigious gentleman, had relished or thrived on the confrontation between himself and the prison officers. And my Lord Bingham noted that in paragraph 5 at page 256. You see the last part of his paragraph. In 3 instances, the bad faith ingredient was established. The judge dismissed the respondent's claim against these officers also on the ground that misfeasance in public office was not a tort actionable per se, and the respondent had failed to prove any financial loss or physical or mental injury of any kind. Indeed, the judge formed the impression that in many ways the respondent appears to thrive on these conflicts. And Lord Roger made the same point at paragraph 38, page 266. I won't take you to it. But we submit that that indicates that the individual attitudes, which the judge is surely right to say would have varied amongst class members, are relevant to the question of harm. My Lord, Mr. Tomlinson went on a little later to invite the court to make a conventional award for infringement of right in this area, emphasizing that privacy, as he put it, privacy and data protection cases do have a special status, and on that foundation suggested that there might be justification for a conventional award. But my Lord, may we repeat a point we made in our case, which my Lord Legate also mentioned yesterday. The data protection regime does not just protect private information. It protects information which is entirely non-private, but can still amount to personal data. And so to lump together data protection with privacy and suggest it by that token has a special status justifying a conventional award would not, in our submission, be a principled approach. And in any event, I repeat, if I may, something I said yesterday, which is the only spur for a conventional award in this area, which Mr. Tomlinson can point to, is the difficulty of assessing individual circumstances. But that is a result of the claimant's choice of procedure, not any other inherent feature of the case. Lord, Mr. Tomlinson turned to user damages and emphasised paragraph 91 of One Step, where he said that this case fits the analysis of something for nothing. The difficulty in our respectful submission is that, as between members of the class, it's not the same something, and therefore a uniform award, which is the real difficulty with this claim, is not justifiable on that basis. Perhaps seeing that difficulty, Mr. Tomlinson proceeded to posit a hypothetical negotiation not between individual members of the representative class, but between some notional representatives of the class as a whole, leading, as we understood this hypothesis, to a lump sum to cover the value of the use of all of the BGI of all of the class members. But, my Lord, in our submission, put that way, that would be a top-down fund, which Mr. Tomlinson accepted at other parts of his submissions would require legislation. It also, in our respectful submission, amounts to manipulating the concept of hypothetical negotiation to suit the representative action procedure in a way which is unprecedented. Still on user damages, maybe a facet of the same point, but Mr. Tomlinson suggested Google had 3 objections to the user damages analysis. 1, that data wasn't property. 2, that Douglas and Hello suggested the negotiations were artificial. And 3, that user damages have only been awarded in very limited circumstances. In fact, my core point on user damages was the inability to achieve a uniform award throughout a disparate class, where both the information, both its extent and its nature, and the use made of it by Google would vary and prevent a uniform per capita sum from being awarded. My Lord, Mr. Tomlinson, then turning to issue 2, dealt with the authorities and referred to certain passages in them. There was some discussion during the review of Marked of the 2-stage procedure which Lord Justice Buckley envisaged, and that led to some exchange in relation to several of the cases about the possibility of a 2-stage approach in which a declaration might be sought, and then on the back of the declaration further proceedings in which individual awards of damages were sought. My Lord, the fundamental difficulty with that is not the case that we face. There is no claim for a declaration. There is no suggestion there will be a 2nd stage of this litigation in which individual circumstances are examined. The whole thrust of this innovative case, as Mr. Tomlinson accepts it is that it allows in one go the award of a uniform per capita sum of damages for every member of the class. And my Lord, there are a lot of cases that deal with the availability of a declaration and its relationship with subsequent relief. We haven't looked at all of those because that isn't the way the case was put. It gives rise to further problems. But my Lord, it's an important point to bear in mind when you come to read the Commonwealth cases. And the reason for that is the Commonwealth cases on which I essentially make these points. Firstly, they provide no support for a uniform per capita award. But perhaps more importantly, both the Canadian case, see paragraphs 39 to 40, that's the Western Shopping Centres of Dutton, and the New Zealand case, Southern Response Earthquakes and Ross, at paragraph 9, envisage separate stages in the procedure. And so it doesn't assist with the analysis of the present case to see that in that context, Commonwealth courts were prepared to allow a representative action to proceed. They help my friend this much, I grant, that they show a judicial disinclination in other Commonwealth countries to await legislation if justice can be done. But they are a slightly dangerous guide to the position we find ourselves in as a matter of legislative background, and in particular, when in the nature of this case. My Lord Sells.
Yes, I was trying to read the Carney case. I think you could fairly make the same point, in effect, about Carney, because there the idea was that things could proceed on a common basis. But if it became clear at any stage that an individual's rights would be prejudiced by proceeding in a common basis, then you stop the common basis at that stage. So in other words, that court also, as it seemed to me, admittedly I'm reading it quite fast, seemed to be contemplating that you take the representative parts of the claim forward to a certain stage, but you don't go the whole way in terms of determining the individual rights that might flow out of that.
Well, Lord, I hadn't yet seen that in Carney, but I'm obliged. That's certainly the analysis that we make of the Western Shopping Centre and the Southern Response Earthquake. In Southern Response Earthquake, it's patently clear, paragraph 9, that second individualised stage is anticipated. And it's clear at paragraphs 39 to 40 of Western Shopping that what the court was prepared to allow on a representative basis was an issue common to all, but nothing more. My Lord, my learned friend said in relation to judicial as opposed to legislative development, well, look at the tort of misuse of private information. There had been legislative initiatives, but the court ultimately invented it. Well, that's a bad point, because of course the court only gave birth to that tort after the Human Rights Act 1998 was enacted, which incorporated into domestic law the Article 8 right to privacy, which was then itself incorporated into breach of confidence to give rise to misuse of private information. So it followed legislative change. Lord, I'm conscious of the time. I need to make just a couple of points about discretion and then deal with Mr. Fichenna's submissions very quickly. On discretion, my learned friend began by suggesting that the Court of Appeal somehow had said the judge was influenced by his views on the first two issues. Well, that's not fair. The judge said at paragraph 104 that he would have decided the case on the exercise of discretion, regardless of his decision on the first two issues. And we have to take him at his word on that. It means he left those factors out of account. My learned friend then began to slightly pull back on points A, B, and C as to whether the judge was right factually on them. My Lord, there was no respondent's notice in the Court of Appeal suggesting that any reconsideration of the judge's findings on those factors was required. And in my submission, that point isn't open to him. He must stand or fall on the two irrelevant matters the Court of Appeal identified, namely the practical difficulties in identifying class members and the authorization. Mr. Tomlinson expressly accepted that the practical difficulties in identification were a relevant factor. Lord, if that's right, weighing that factor was for the judge. That is orthodox. On the other factor, whether the members of the class had authorized, in my submission, it's not right to say that will be a constant throughout any representative action, and therefore not a matter which, on the facts of an individual case, may be relevant to the exercise of discretion. The judge didn't state it in the abstract. He explained about the passage of time, the high-profile Vidal Hall litigation, and so on, and then took that factor into account in a way we say he was entitled to. My Lord, in my closing minute, if I may just explain what I say in response to Mr. Fichenna's submissions. Once you focus on the judge's approach at paragraph 59, which is to say that loss of control can have significantly harmful consequences. There is really very little between Mr. Ficena and the appellant, because he recognises that all losses of control are not equally serious, and some may be of such limited seriousness as not to call for a remedy of compensation. The judge's approach achieves exactly the same results, which is looking at loss of control not as a uniform creature or homogeneous creature, but as something which may have significantly harmful results, but won't necessarily do so. But even if you're attracted to the submission that loss of control can of itself be harm, my final point, and it's enough for me on this appeal, is that not all members of the class will have suffered the same loss of control. And that will do for my purpose. Lord, unless I can help further, those are my submissions.
Well, thank you very much, Mr. White. We're grateful to counsel for both parties for their very helpful submission. And we're also grateful to the Information Commissioner for Mr. Ficena's assistance, and to the other bodies which have intervened in writing. We'll now take time to consider the submissions and issue our judgment in due course. The court will adjourn.